Hello Reddit, we're just heading out now to meet with Pete Tormey, who's an IP lawyer, and he's gonna give us the laydown on what to do with the microphone bull.
Well, I'm a patent attorney, and I'm a little bit unique in the sense that I actually had a software company doing mobile app software in the 90s, and I came into patent law a little later. When I look at patents, when I evaluate inventions, I usually start, when I'm dealing with people bootstrapping, paying their own way, I usually ask the question, how are you going to make money with it? There's this myth out there in the patent world that if you have a patent, you're going to become a millionaire.
Right.
And every now and again, a patent does that, but it's pretty rare.
Yeah.
And most people apply for patents. They spend a lot of money on patents, and they might be better off spending the money marketing their product. A patent might not be their best avenue to make money, at least initially.
Right.
And there are a lot in the United States, at least until March, and then it gets a little bit murky till March 2013, is that you have a year from the time you invent till the time you apply for a patent. Of course, you run the risk that people steal your idea, and you'll have a little lawsuit to figure out who invented it first and those type of things. You don't want to get bogged down in that type of stuff.
Right.
So most people file for something like a provisional application, go find out if there's a market for it, and then they start sinking money in IP.
So with the microphone bull project, for instance, it would make sense to do a provisional patent first rather than do the whole full thing.
Yeah, you'll save some money. And right now, you have to find out if it's profitable. So normally, if they're bootstrapping, I recommend you get a provisional patent application, and then you have a year to file for the regular utility. And presumably, in a year, you'll have your act together.
Yeah, I mean, with this project, if we're not making money in a year, then
you're going to walk away.
You're going to walk away,
And so, this is fairly low tech product.
Yeah.
In a high speed technology area, maybe you'll dispense with the provisional because you want to get claims allowed as soon as you can.
Right.
But usually that's a game for the big boys and not necessarily for the bootstrappers. Bootstrappers are going to use their patents defensively to protect themselves, usually not to go after other people.
Yeah. My primary concerns with this would be to be sued by someone else who had the patent, or some big corporation just decides to take my idea and go away with it.
Run with it. Yeah.
And that provisional patent would provide me with some defense for those two scenarios?
There's two different scenarios.
Yeah.
The provisional patent won't stop you from getting sued. In the United States, nothing stops you from getting sued.
Right, yeah.
What a provisional patent will do is if it issues to a regular patent, it'll give you the right to go sue an infringer, right? Which is a very expensive proposition. But there's usually negotiation on the way, so hopefully you don't end up all the way going through trial. The other and more trickier scenario is, what if somebody already has a patent on this and I'm infringing on their patent? There's several schools of thoughts on this legally. There's and they run anywhere from don't worry about it. If you're infringing someone, they'll send you a cease and desist letter, and you can worry about it then.
Right.
To the other extreme is they don't do anything because they're so afraid someone's got a patent. Well, it turns out in the United States, patents aren't normally published for about 18 months. So even if you do a search, someone could have already applied for a patent on it. So there's always an element of risk. You're better off going to Google Patents and making sure that no one's doing it than not. Because you'd hate to be 3 months down the road or 6 months or a year down the road and have someone already patent obviously the exact same thing. And that happens. People call. While they're on the phone, I'll bring up Google Patents and I'll find it.
And you'll be like,
I'll say, you want to tell me what's different from this patent? I don't do that all the time, but...
Right.
When we look at products as engineers and attorneys, we break it down into elements and we search for elements. And it's a little more complex, and the average layperson can't do it until they're trained. In order to have a patent in the U.S., you have to be novel, and you have to be non-obvious, and it has to be useful.
Right.
And when we look at what's new, merely just putting two things together isn't necessarily new. So in this invention here, what you have is a wireless microphone wrapped in foam, right? So that you can throw.
Yeah.
But if I were to ever... ship a wireless microphone, I'm going to wrap it in foam.
Yeah.
So you have a little bit of a problem of the novelty aspect here.
Right.
We'll talk about that later. I just want to get that on.
Okay, that's
so assuming we meet all that kind of tests, that it's new and not obvious. In the United States, you have a year to apply for a patent. What you'd like to do normally is get a patent applied for, provisional in this case, so you can go test market. What that takes is a writing to the patent office that describes in detail how to make the invention and how to use the invention. And there's a little bit of art to drafting patent applications, and I'll give you one example of them. You could probably tell me how to do that in a couple of sentences, right? I think, in fact, when I found out about it, I think I got a 2 sentences or 4 sentences.
It's not very complicated.
You're also holding it in your hand, so it was easy. But what happens is that when you say, let me give you an example. When you're an inventor and you have to put two pieces of steel together, so you bolt them together. So you write on your patent application, two pieces of steel bolted together. What a patent attorney will do is say, yeah, you can bolt them, but you can also screw them together.
Yeah.
You can weld them together. Maybe you can button them together, whatever. So instead of saying with a bolt, we will say with a fastener, such as a screw or a bolt or whatever the case is. So what we try to do is broaden the description so there's nothing in the application that narrows it completely, because you want the broadest patent you can get.
Yeah.
And what's a difficult concept for a lot of people is when you look at patents, the patent's not going to issue for a little while.
Yeah.
So you want it's forward
So you'll
looking.
be kind of a bit ahead
17
of the curve.
years from when it...
Right.
If you could think back 17 years ago, what was out on the market, Palm Pilots were mobile apps.
Yeah.
Right? You're trying to say, when I write this patent application, what could be out there in the future that will affect it? So you use very broad terminology.
Right.
You want a complete set of drawings to show people how it's done, because a picture's worth 1,000 words. A complete set of drawings, how to make and how to use the invention, so that somebody having what you would call usual skill in the art, and that depends on who that person is. If you're a software engineer has to be able to do it. Does it mean every software engineer? No. But presumably you can find a Java guy and he would understand what you're saying. Yeah. At the end of the day, you want it to sail past the patent examiner, because that just saves you money in the long run.
So one thing I noticed when I was going through a lot of the patents as well was a lot of them were described in terms of method for doing so and so.
That's
and
right.
Is it actually possible to patent the method, or
Absolutely.
how does that work?
Yeah. In fact, method patents can be very strong.
Right.
And it's easy, if you think back in industrial days, a method of making steel was patentable, right?
Right.
Because you're going to have different amount of carbon for whatever, different types of steel. So what we call them business methods. A way to make something is actually much more broader than the thing that's actually made, or can be much more broader than the thing that's actually made. So it's one thing to say, I have a foam ball with a wireless microphone on it. It's another to say, selecting a microphone with a certain criteria, meeting what...
So I have a method for audience interaction and participation.
Or something like that. You might not want to narrow your method that narrowly, because it doesn't have to be audio.
Right.
I mean, we were talking earlier about other applications for this.
Yeah.
So this is the way. This is just the art of doing patents, because I said,
so that's where
don't narrow anything.
Exactly.
It's just a method. A method is fine.
But it's finding a balance between being general enough, or as general as possible, without being too general, in order to
so that somebody can make this. When I claim, a wireless microphone stuffed in foam padding, surrounded by an outer clothing with some animated characters on it, or whatever the case is.
Yeah.
I've just broadened very much what you would have described it.
Right. Yeah.
So what you want is enough so that somebody can make it and use it, but not narrowing it in any way. Yeah. So the uses, you may have one use, but there may be 100 uses. We don't know what they are.
Yeah.
So you put several examples. It's the difference if you think of like flowers. You have genus and species, right?
Right.
You have roses, you have daisies, you have whatever, and then you have the genus that covers all of them.
Yeah.
You want the genus and then examples of the species when you write it down. Now that's I'm sure people watching this video are going to look and say, what the hell does that mean?
Right.
But the reality is that's what we try to do in the art.
How would I go about, taking the next steps with something like a provisional patent? Would that be a good time to involve someone like you?
Absolutely. Yeah. And the best thing, what you want to do is save me money.
Right.
The less time I have to spend it, the better price I'm going to get.
Yeah.
As a lawyer, I don't have the option of saying, I'll do it cheap, but I'll do a bad job. You can tell the guy, just put one coat of paint on my house, right? And he'll say, yeah, I'll do it in an afternoon, we're done. It's not a good paint job, but you got a good price, right? Lawyers don't have that option. With that said, the best way to save me money is to draw the thing up, write a description of how to make it, and write a description of how to use it, and tell me what you think is important. In this case, I kind of know the whole product is important. But often when someone comes in with what they think is an invention, there are several inventions, and there's several parts to it that may be patentable. And those building blocks may be more valuable than the total thing made, because the building blocks can be used in other places. So the best thing you can do is spend a little time and write down exactly how to make it, and how it's used, and draw the pictures, and give them to me. Provisional patent applications don't need formal drawings. And give them to me. When I look at it, I say, I don't need to spend a lot of time on this. That'll be reflected in the price.
So I can do the best to my ability in terms of basically drafting up a provisional patent and then hand it to you, and then you'll
go through and I'll rewrite it, but at least I'll know what it's there.
Right.
The big risk with a patent attorney, I think, is that the patent attorney doesn't understand the invention.
Yeah.
And in this case, it's very simple, so it's easy. It changes a lot when you start to do things like working in like software in very specialized environments and things like that, or a lot of the cutting edge, cloud computing stuff where the words we're using aren't necessarily defined yet. Or they have multiple definitions and we haven't gelled on one, and then we have to be.
So that's where it would make sense to get a patent attorney who's known in the industry and who knows the field and the market.
Who knows the field? Presumably they will. They'll know that they shouldn't. I'm sure there are attorneys who don't follow this, but you want someone like I do a lot of software and electronic type stuff. So you want somewhere that you can look in the record and say, okay, he's got some software patents behind him.
If we move on to next steps with the microphone ball, then primarily the areas, based on what I understand, it's the method for interaction and maybe the actual ball itself, but you can maybe.
Well, you probably, if you're going to do the method of making the ball, you want to do the ball itself.
Okay. Yeah.
Yeah. Let's talk a little bit about provisionals before I forget.
Okay.
Two things. Yeah. Provisionals expire in a year. You have to file for a utility within a year, and I think a lot of people forget that. If I file a provisional for you in a year, I'm going to come back and say, "What are you doing with this?" You don't want to be surprised then that you need a utility.
Yeah.
And the second thing is that on a product like this, the trademark, the name of it is going to give you the trademark is likely to be more valuable intellectual property than the patent, and it costs less to get. When you get to something like this, you want to think very carefully about your product name and your trademarking structure, because that will propel you forward over the long haul than any particular product you're likely to come out with today.
Okay, cool. So, I mean, that's covered a lot of the bases. Is there anything else that I should be thinking about at this point in terms of legal stuff, with patents?
No, I think we pretty much covered the patent world. At least it's off the top of my head. I think that's pretty much what it's covered.
Well, Pete, thank you so much for your
You're
time.
very welcome.
Really appreciate it.
My pleasure. Yeah, it's fun. It's funny too.
All right. Just for the camera, do you want to say something about where you work and
how people
can contact you?
I'm Pete Tormey again. The website is antlegal.com, Ant Legal, and we're located right in downtown San Francisco. Yeah. So we spend a lot of time with startups, a lot of time with software and electronics.
Thank you so much, Pete.
All right,
really
you're very
appreciate
welcome.
it. Yeah. I'll just press stop there.